आइडियोलॉजी को देखते हुए, बिना इस किसी बात को देखते हुए हु इज़ पावरफुल और हु इज़ पावरफुल नॉट। जस्टिस वो है जो किसी भी प्रेशर में कभी झुकता नहीं है। मेरा ये रिज़ॉल्व, हर जज का ये रिज़ॉल्व रहा है, रहा था और रहेगा। माई फाइडेलिटी, माई लॉयल्टी इज टू द कॉन्स्टिट्यूशन, जो मैं बिना किसी हिचकिचाहट के, विदाउट हेजिटेशन, बिना किसी डर के, फियरलेसली मैं एडजुडिकेट करूंगी, बिना किसी डर के, बिना किसी भेदभाव के, बिना किसी फेवर के। और मैं क्लियर टर्म्स में मैं ये होल्ड करती हूँ दैट आई विल नॉट रिक्यूज। मैं इस केस से रिक्यूज नहीं करूंगी, मैं ये केस की सुनवाई से नहीं हटूंगी। An issue between two litigants. Unfortunately, today it is not a dispute between two litigants that I have been called upon to decide. It is between the litigant who is discharged accused and myself, the judge. The rope that this court wears will not be allowed to be weighed down by insinuations. The arguments and pleadings before this court have fallen short of the standard required under the law and jurisprudence of recusal. Allegations and insinuations, though persistent and loud, can never take place of the proof required in law for seeking recusal. Judges are expected to bring to the bench an open mind and not an empty one. For decades, that steadiness has not been a choice but a duty with me. A judge cannot recuse to satisfy a litigant's unfounded suspicion of bias, not to avoid discomfort felt by it due to manufactured allegations. Accepting the present application would also mean giving credence to an attempt to cast a shadow of doubt on the fairness of a judge without any material, and then insisting that such a shadow alone is sufficient for the judge to recuse from the case. This court has remained indifferent to the stature of the litigant appearing before it. In case this recusal is allowed, the judicial process would not remain independent but vulnerable to insinuations which can be put under pressure of such unfounded allegations and thus became selectable and strategic move in the hand of a litigant. This court will stand up for itself and for the institution when such standing is required, though it may appear difficult. This court will decide when duty demands that such case is to be decided, even if inconvenient, and will not yield or retreat where doing so would erode the credibility of the institution itself. The rope of this court wears is not so light that a mere whisper of accusation it would seek refuge in recusal where no reason for such recusal exists. If recusal on such ground is accepted, it would risk the adjudicatory process being shaped by the preference or discomfort of a litigant, and in that case, it would not be justice administered but justice managed. This path is not permitted by our Constitution. The personal apprehension of the applicants, howsoever persistently advanced, have not been able to pass the threshold test of reasonableness of bias, where a fair minded and informed observer in the facts and circumstances of this case would conclude that there exists a real apprehension of bias. Recusal has to stem from law and not from narrative. This court understands that it is a defining moment in this court's judicial life and that this order would decide as to whether I will stand my ground in performing my duty or allow myself to be moved or unsettled by the ground beneath my feet, being sought to be shaken by accusations thrown at me. If the grounds raised in these applications were to be accepted as valid grounds for disqualification of a judge from hearing a case, the qualification for judicial office itself would have to be redrawn, suggesting absence of a family, absence of past association, and complete absence of social or official engagement with the bar. The Constitution, fortunately, does not prescribe such solitude as a qualification to be a judge. As curtains are drawn on the arguments in these applications seeking recusal, I must add, in this case, the file seeking recusal did not arrive with evidence. It arrived on my table with aspersions, insinuations, and doubts cast on my fairness and impartiality. Though quietly worded and couched in legally assembled sentences, yet carrying much beyond the phrases. The applications were not questioning a decision, but whether the decision maker would make a decision. The easier path of recusal would have offered a quiet exit, avoided, avoided discomfort, and closed the manner without confronting the allegations, suggestions, and insinuations. However, this court knows that the office of a judge demands restraint and silence. Yet, such restraint and silence must not cause injury to the institution itself. Every unproven and unfounded accusation of bias or partiality is not merely a question put to an individual judge, but also casts aspersions upon the collective integrity of the institution of the judiciary itself. It is for this reason that this court has decided to speak through this judgment, not to defend myself, but to defend that collective trust. This court is conscious of the constitutional office it holds and the discipline it demands. It has no personal interest, direct or indirect, in the outcome of the present matter. The allegations leveled, the grounds raised, and the associations referred to, as discussed above, were neither proximate nor relevant to the issue in question. What lends a deeper disquiet to the present application, as also submitted by the learned Registrar Solicitor General, is the attempt to attach a media driven narrative to the proceedings, including instances of vilification without accountability. This court, being trained to remain uninfluenced by such external narratives, has proceeded to decide the matter uninfluenced by any such pressure. The rule of law is not upheld on the basis of repeated allegations or media headlines, however persistent or widespread they may be. It rests on the objectivity and impartiality expected of a judge, which this court has adhered to. At the same time, the subtle attempt to discredit the institutional integrity of the court and the concerns arising therefrom have been rightly placed on record by the learned Solicitor General. The powerful and the powerless are equal before this court. There may be a political figure as one of the respondent applicants before it. However, the law remains completely indifferent to the status of a litigant. The courts stand firm in their duty to treat all litigants equally. The office of a judge also demands detachment from self, or the self must yield to the credibility of the institution. If this court was to recuse, it would not be prudence, but abdication of duty, and would amount to lending legitimacy to aspersions, insinuations, and doubts when no ground for the same exists. It would be an act of surrender, quiet and convenient, yet not without consequences. The signal that an institution can be bent and shaken by unverified assertions would travel far beyond this case. What I am saying is, मैं ये कह रही हूँ कि अगर मैं बिना इस एप्लीकेशन को सुने मैं अपनी ड्यूटी सरेंडर कर देती और मैं अपने आप को रिक्यूज़ कर लेती, तो शायद ये रास्ता मेरे लिए बहुत आसान होता, क्योंकि ना कोई मुझे कुछ कहता और ना मेरी फैमिली को कुछ कहता और ना कोई नैरेटिव चलाता। लेकिन ये इस इंस्टीट्यूशन के फ़ायदे में नहीं है, ये इंस्टीट्यूशन के हक में नहीं है कि मैं बिना उस बात को एडजुडिकेट किए मैं अपनी ड्यूटी को सरेंडर कर दूं, क्योंकि मैंने अपनी ड्यूटी सरेंडर करना सीखा ही नहीं है। मेरा रिक्यूज़ल, अगर मैं रिक्यूज़ल करती हूँ तो उसके क्या रेपरकशंस होंगे, उनको भी मैं अपने माइंड में लेके चलती हूँ कि शायद सोसाइटी में लोग ये सोचने लगेंगे कि किसी भी जज को, किसी भी कोर्ट को प्रेशराइज़ किया जा सकता है और उसको बदला जा सकता है। तो जब मैं ये डिसीजन करूँगी, तो मैं इस बात को भी ध्यान में रखूँगी कि मेरा डिसीजन जब जनता के पास पहुँचेगा, तो उसका क्या प्रभाव पड़ेगा। Far more profound be the effect if such insinuations were allowed to be closed merrily in the file by this court recusing, as they would continue to linger in courtrooms, in public discourses, in law schools, and in general understanding of what real justice means and what it does not. It would also mean that the judiciary can be compelled to yield not to reason but to narrative, diminishing the trust that justice must continue to command even when tested. This court will not permit that faith to be eroded or cause allow damage to be caused to the judicial system. अगर मैं रिक्यूज करती हूँ और बिना ये बताए अगर मैं करूँ कि मैंने क्यों रिक्यूज करने किया या नहीं किया, तो चाहे ये फाइल क्लोज हो जाएगी, जो भी इन लिटिगेंट्स ने कहा वो क्लोज हो जाएगा, मगर जो ये डिस्कशन स्टार्ट किया गया इन एप्लीकेशंस के माध्यम से, वो कभी कोर्ट रूम्स में चलेगा, कभी बार रूम्स में चलेगा, कभी कॉलेजेस में चलेगा, और हर एक व्यक्ति ये बोलेगा न्याय क्या है, न्याय की प्रक्रिया क्या है, और क्या हम किसी जज को डरा के और प्रेशर करके हम अपना जज चेंज कर सकते हैं. The applications seeking recusal are therefore rejected. And in this rejection, this court affirms its fidelity to the Constitution on behalf of myself and every judge who stands by it. Justice lies not in yielding under pressure, but in doing justice objectively while enduring that pressure. Has been, and will remain the solemn trust, quiet strength, and unwavering resolve of this court to remain faithful to this oath, to not choose the easier path of recusal, but to walk the path shown by the Constitution unhesitatingly, fearlessly, and adjudicating without fear or favor, and state in clear terms. मैं यही कहना चाहती हूँ अपने जजमेंट के माध्यम से कि मैं ये एप्लीकेशंस रिजेक्ट करती हूँ, क्योंकि मेरी ओथ कॉन्स्टिट्यूशन से है, क्योंकि मुझे मेरी ओथ ने ये सिखाया है कि जस्टिस प्रेशर में झुकने से नहीं होता. जस्टिस बिना किसी प्रेशर के, बिना किसी पॉलिटिकल आइडियोलॉजी को देखते हुए, बिना इस किसी बात को देखते हुए हु इज पावरफुल और हु इज पावरफुल नॉट, जस्टिस वो है जो किसी भी प्रेशर में कभी झुकता नहीं है. मेरा ये रिजॉल्व, हर जज का ये रिजॉल्व रहा है, रहा था और रहेगा. My fidelity, my loyalty is to the Constitution, जो मैं बिना किसी हिचकिचाहट के, विदाउट हेजिटेशन, बिना किसी डर के, fearlessly मैं एडजुडिकेट करूंगी, बिना किसी डर के, बिना किसी भेदभाव के, बिना किसी फेवर के, और मैं क्लियर टर्म्स में मैं ये होल्ड करती हूँ दैट आई विल नॉट रिक्यूज. मैं इस केस से रिक्यूज नहीं करूंगी, मैं ये केस की सुनवाई से नहीं हटूंगी.
He wants to say something, if he may be in.
Yes. People, you are appearing in this case? No, are you not appearing in main matter? नहीं, आप मेन मैटर में आप एक अक्यूज को तो रिप्रेजेंट कर. नो, यू आर नॉट. ओके, सो नाउ द मेन मैटर वाज आल्सो लिस्ट. यस, वो कुछ कहना चाहते हैं, अनम्यूट कर दीजिए प्लीज. उन्हें अनम्यूट कर दीजिए प्लीज.
Oh, it is logged. He's trying.
Lord, your ladyship, let me say this, my lord, leaving the brief aside, and only as a student of law, your ladyship has really upheld the oath of constitutional office of deciding without fear. This is really a defining moment for the institution. And the best part, which I found again as a student of law, forgetting that I'm appearing in the matter, that there is no bitterness in the entire judgment against the petitioners. Your ladyship merely laid down the law on recusal and how an upright judge would deal with such a matter. I'm really grateful for that. My request is
this is the judgment that I had to pronounce. There will be still something that I may add. And the last paragraph of this judgment has to be that despite the fact that I will not recuse, despite the fact that I have decided these applications, please, you can please write it. Despite the fact that I have decided these applications, I will decide the main matter without being affected by these recusal applications, as a judge is required to decide the case without fear, favor, or feeling that these applications were ever filed in this case. मुझे कभी भी, जब भी मैं इस केस को डिसाइड करूंगी, मेरे माइंड में कभी भी ये वे नहीं करेगा कि कभी ये एप्लीकेशंस फाइल्ड भी की गई थी. एंड एनीथिंग दैट आई स्टेट इन दीज एप्लीकेशंस is only for the purpose of adjudication of these applications, which will have no bearing in case when I will hear the main matter. So that's
the majesty of law. That's the majesty of